Okay. On that note, I'm not 11 years into my term in the legislature. I'm about 5 months into my term in the legislature, and I'm going to do the best I can here on this bill. I want to start by saying that, Assemblymember Wilson, I'm happy to see you standing vertically in front of us, brave with your bald head and all, and presenting your bills, not just this one, but all of your bills. That's really honorable, and I know you're fighting your own battles, and I'm just happy to see you standing in Sacramento today. I called her yesterday because I had a lot of concerns about the bills. I didn't want to bother her because she is dealing with a lot of personal health issues, and but I felt like I was hearing from so many people. And if you were keeping track today, it was like a parade of my constituents on both sides. These are the tough ones, when people you care about are on both sides of an issue. And my office has been inundated with thousands of calls. I am a lifelong Democrat. I am a Christian. I am a mom. I consider myself to be a strong ally of the LGBTQ community. I do have situations similar to this in my own family. And yesterday, my very good friend Doug Pfeiffer took his own life, and he is a member of the TGI community. He's not a child, but he is a young man. And I'm trying to take all of that in. I want to take nothing away from anyone's experiences here. I watched carefully as people spoke, and folks spoke passionately on both sides, and you all have deep personal experiences. What I want to say to you on both sides is any parent who stepped to the mic today and said, I love my child more than the government ever will, I believe you. I know you do. This really wouldn't change your outcome, because what this bill actually does is already in the bill if a good judge is sitting in front of you, because the bill calls for the judge to weigh all the circumstances affecting the child's health and well-being. If it were to come to the attention of a judge, and I too have a law degree and have sat with many families, if it were to come to the attention of a judge that the child was somewhere in a fluid discussion around gender, the judge would ask, they would already do this, they would already ask, does this child have, as Senator Caballero said, family support? That is going to be a reasonable question. What I shared with the author is that I'm having trouble, my law degree mind is forcing me, like Senator Allen very eloquently stated, to have trouble accepting a bill with terms that are not codified in law, because of exactly what Senator Nilo said. People are conflating child abuse. This isn't even the penal code. This is only in a divorce proceeding. This doesn't have anything to do with that. By the way, in this particular code, even if you were an alcoholic or you had a substance abuse, it wouldn't be a penal code violation under this section of the law, because this is only about custody. It is just something that the judge is taking into consideration when they're trying to make the best decision on behalf of a child. So when Senator Nilo said that things are being conflated, like actual health care with affirmation, and Assemblywoman Wilson says she means affirmation to be the plain language definition of family acceptance and support, that I understand. And I think there would be broader support for that language. So I would like to echo Senator Allen and Senator Caballero, and I believe Senator Nilo's comments, that I'm hoping for some clarification when this comes to the Senate floor and then, goes back to the Assembly and on to the governor. It needs clarification, because there are so many people out here who spoke to language that isn't actually in this bill. But I understand why they did. And I've seen, the Twitter warriors who are particularly venomous towards Senator Wiener. And I read this bill so many times, called some colleagues more senior to me and asked them what they thought of the language, sat down with them, called people I know in the community, tried my very best to do outreach, to read messages, to become as informed as I possibly could, and even called you. I know that the process in the legislature is a little foreign to the audience. It was to me too. I'm still getting used to it. Like my colleagues, I want to give you the time to make that clarification. The only way to do that is to support you today. I also think what you are seeking to achieve as the mother of a trans child is noble and righteous. But I also want to hear the voices of all the people in the room that are saying, what exactly does this mean? Or they've already decided what they believe that it means, but the law does not bear that out. At the heart of this bill, it is about judicial discretion. That is really what this is about. And for me, both in my professional career and here as a legislator, I have been a supporter of judicial discretion, because judicial discretion means we give the judge as much information as we can, and we ask them to make the best choice and decision that they can based on their experiences. Our system is really set up that way. As Senator Laird said, this question does not become the paramount question. It does not become a question that leads to some penal code or some action taken by CPS. CPS is not involved in these proceedings, nor would they have time for this. This is just about making sure that a child is in a loving, supportive home. And when I think about the number of kids who have taken their own lives because they didn't feel they were in a loving, supporting home, I feel like it is a relevant and righteous question for judges to ask when they're going through this proceeding. So I'm going to support you today, Assemblywoman Wilson, but I'm going to join my colleagues in asking you to work with Senator Umberg as Judiciary Chair on adding some clarifying language that makes it clear that you are really seeking family support and acceptance for children who are working on their self-identification, gender identity. Thank you.